R-Y-A-N.
Call in if you want to speak with someone.
Well, see, when someone requests a CO, you're supposed to bring a CO. That's not how it works.
You can call in if you want to speak with Mr. Ryan, what's your middle initial?
C.
And what's your date of birth?
8888.
All right, so 337.406, Florida statute. Look it up if you want.
It's all right. I'll be back out here in 5 minutes doing the same thing I'm doing because, wait a minute, listen. I understand you think you're doing, what you're doing is right. So we're going to come back out because I need a citation. Because in order to fight that, we have to get a citation, right? For an unconstitutional.
We give a warning first. That's what it says in the statute.
Well, then I'll stay out here until I get a citation.
Okay. So
then I'll stay out here until I get a citation.
There's no citation. It's a misdemeanor, so you can technically go to jail for it.
Sick.
You don't want to do that.
Sick. 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 But like I said, I'll be right back in 5 minutes. Oh, I don't mind going to jail. But I'll be back here in 5 minutes. Because that's why we're suing Hillsborough County, because they arrested me. So like Daniel in the Lion's Den, you ever read that scripture? I don't mind going to jail.
Okay, well, we don't mind taking you.
But yeah, I'll be back in, it might take me 10 minutes because we're parked quite a ways.
Of a state right away.
Yeah, you can say whatever words, you're still wrong.
That is literally
you're still wrong.
Website
yeah, I know, but you're still wrong. It's an unconstitutional law.
Well, it's still a law that's been written.
You're right, which means I got to go to jail in order to fight it. Right? Or get cited or whatever it is. But anyway, I'll be back. Give me 10 minutes.
Hello, this is Sergeant Powers with the Alachua County Sheriff's Office on a recorded line. May I speak to Andrew, please?
This is he. How you doing, Sergeant Powers?
I'm good. How can I help you today, sir?
I'm calling. I'm a data analyst with Audit Crimes. We do a project called Homeless Audits, and I've been working. I have an autistic daughter who's currently having an episode where she's crying. So it makes it difficult. I'm gonna have to walk away, and my wife's at work right now, so I'm having to kind of babysit. All right, so we had a recent audit that where there was a deputy by the name of Myers, S. Myers, stopped one of our auditors by the name of Ryan Kirby. He was stopped at the Tower Road and Newberry, and he was told that there's a Florida State Statute that prevents the act of holding a sign, passively holding a sign on the right-of-way that is not soliciting or asking for anything. That's a statement sign, which, you know, a lot of people would count that to the word panhandling. And we hold that panhandling has been a protected right supported by basically every court in the federal courts throughout history. And most recently in cases like Messina versus Fort Lauderdale, Scott versus Daytona Beach, and various cases straight out of Florida where ordinances through county ordinances have been repealed quite regularly when they're challenged by Florida Justice Institute and various other organizations that have the civil rights attorneys. So the courts maintain on the judicial side, they keep ruling in the favor of free speech. On the legislative side, it seems like they keep writing legislation that has to do with the spirit of the law is traffic flow issues or safety and health of the population, which are very much in line with the Constitution of various states having control over the safety and health and welfare of the populations. But they seem to be being implemented against people who are passively holding a sign on the right of way, which seems to be a conflict of what the spirit would be in the legislative end. And those actions seem to be going on by the executive branch, law enforcement officers. And sometimes the executive branch has a piece of legislation that was written for one reason, and then they start applying it for reasons it wasn't written for. Then sometimes the legislative branch writes things that are unconstitutional, and the judicial branch has to rule them unconstitutional. And this is just how America works. So in this case, he quoted Florida State Statute 337.406, which is unlawful use of a state transportation facility right-of-way. Are you familiar with that statute? No. You're not. I wasn't either. That's why I called you. So I read it, and while it does apply with anywhere outside of a municipality, an incorporated municipality, and our auditor was outside, there's some language that I wasn't really 100% aware of what a state transportation facility right-of-way was. compared to like a public easement or a right of way on a roadway if they're just using new words that I wasn't familiar with. And I wasn't familiar with the application of the law. I hadn't seen any federal court cases concerning this particular statute. But Deputy Myers was in Aldus. Aldus was with him. Aldus is the one who kept on mentioning that state statute. So Aldus was comfortable standing behind it exists, and it does exist.
Pretty much, I told him that I need a ticket because if there is in fact a law, an unconstitutional law, I need it to be enforced in order to fight it. He said there was no ticket. However, I'd be warned, and I'd be like, I'll stand out here till I get a ticket then. And he's like, well, there's no ticket, we'll take you to jail.
So that kind of puts you in a pickle where if there's an unconstitutional ordinance and they give you a citation, your liberty's not in jeopardy and you still get to challenge something that
pretty much I have to go to jail in order to fight an unconstitutional law, which I will do today. By the way.
Yeah, so that's why we're calling you first, is because we're trying to figure out what's our next step.
That the deputy didn't arrest you? Or
No.
Oh yeah, yes. Yeah, no, you are. You're upset that he didn't give you a citation or any kind of paperwork that you can then challenge because it sounds like an unconstitutional. It's being applied in a way that's unconstitutional according to the federal courts and state courts. So, we're talking about even Florida courts have found this activity to be unconstitutional.
I mean, this isn't our first rodeo.
Yeah. So if routinely panhandling is a constitutional right, that's routinely ruled on. So, but in order to rule on it, you have to enforce it. I mean.
So you're upset that he didn't enforce it. That's what you explained to.
Well, I mean, we're upset that we don't understand it. Do you understand it? Because you just told me you didn't.
I said I'm not familiar with it.
Can you get familiar with it and give me a call back?
I see the same things you do. It is authorized by the rules of the department is unlawful to make any use of the right of way in any state transportation facility, including appendages thereto. I mean,
what is a state transportation facility?
I don't know why the word facility is in there and not roadway. That doesn't make much sense to me, but it's not offering a definition for it either.
That's good. Yeah, that's where I was
I
at.
think they mean bus terminals.
Well, it might be bus terminals.
Yeah, and things like that. Hospitals.
I think you're right. I think they mean bus terminals, like public transportation facilities. So like train stations, bus.
Yeah, that's what they mean.
Well, where's the, so now see the thing about legislation is there's definitions. I don't like to.
Your point. You called to complain that the deputy did not enforce the law against you so that you could fight it.
Yeah.
Deputies have a certain amount of leeway in the application, and just as you'd mentioned earlier, the spirit of the law versus the letter of the law, they have a certain amount of leeway that's offered to them by the sheriff or the men so that they can make up their own mind whether they wish to pursue crimes of this nature or educate.
Well, that sounds like a threat of unconstitutional of rights violation. Is either an idle threat or it's a threat to get people to comply with an unconstitutional order. So, as auditors, it's our job to find out if that's true, but we can't. What?
I'm not going to make him cite you or arrest you if he doesn't want to.
Well, I mean, if you're not enforcing it, there is called equal protections under the law. So equal protections under the law is also a constitutional right. So there are, what you're saying doesn't quite make sense. Like they have discernment, but if there's legislation on the books that's saying the word state transportation facility, and you've got Deputy Aldus out there telling someone holding a sign that what he's doing is illegal based on that Florida state statute, then he's either going to enforce the law, which is his job, or he's going to use a terminology that is not appropriate for the situation. But as you said, which was exactly my thoughts, considerably my thoughts, is the term facility is in that legislation. And there is no other place in Black's law or any other place that the word facility refers to a roadway.
Okay.
It wasn't an accident.
So we would like to be to have enforcement of that statute in the most realistic approach, and that would be a citation.
Okay. Again, I am not going to take away their discretion on how this particular law is applied and force them to write you a citation or arrest you. I'm not going to do that.
He's saying he'll let them arrest you, so he's not going to take away their discretion.
He has discretion.
Go out there and get arrested then. That's what you do. Just go out there and get arrested. We'll just bail you out, and then we'll sue him.
I'm telling you, you shouldn't break laws. You put yourself.
I don't believe that's against the law. I think it's a constitutional right. I don't believe you could turn a constitutional right into a law, into a crime. And I believe Justice Clarence Thomas made that very clear. It's a constitutional right to have to be.
Legislative branch. I mean.
But the legislative branch didn't say it's illegal. You're the your Deputy Myers or Aldus is the executive branch. He's claiming something is a facility that I've never seen described as a facility. You're saying you're going to give him discretion to misinterpret it.
Described as a facility doesn't make it untrue.
That's what definitions and legislations are for. That's what the definitions are for. We don't get to decide the definitions or use them loosely the way we want to use them. They're written within the legislation.
Unless you think you're better than the judge.
But but who would know until a judge gets to make that decision? Yeah, I mean, so go out, get arrested for this, let them arrest you for this crime, and if it doesn't matter if you get convicted or not, it's still you have a constitutional right to hold a sign that's lost wages, and we just sue them and get an injunction against the ordinance. No big deal. So. However you want to play it.
Good luck. Good luck to you. I'm not.
All right, sounds good.
You not to do that. I can tell you not to break any listed laws.
But you can't tell me not to perform a constitutional right, though. Nor would you want to, right?
You can't scare me away from a payday, buddy.
No. All I'm telling you is don't break any laws as they are written. So
I do not believe this is a law, and you don't seem to know
whether or not to arrest you or cite you or.
I mean,
but you're the supervisor, so you're the supervisor, and you're saying that you're going to give an officer the discretion to misinterpret a state statute because
that's your judgment.
Well, I mean, obviously, state federal court has ruled it be unconstitutional to have ordinances against panhandling, so it's not my judgment. It's Florida courts as well as federal courts' judgment.
The law doesn't actually state panhandling; it doesn't make any use of right of way.
It absolutely says solicitation on there. It has a bunch of different things it states. It's not
going to fall under any use, right?
It's not no, it doesn't say any use. No, sir. It has content-based language in there.
It does say any use. I'm looking at it right now.
Well, then why does it say including?
It's unlawful to make any use of the right of way, etc., and so forth. It literally says that. I cannot quote it any more directly. I'm looking right at it.
Any use of the right of way of facilities. Oh, so yeah, facilities. The bus term facilities.
Facility.
Yeah. Yes.
Roadway. Facility.
Okay. Yeah. He just tried. He just pulled a hoodoo on me. He tried to do that the Jedi mind trick thing. Facility.
There's no Jedi mind trick.
Yeah. The word facility is there. The word facility is there.
And I understand your argument, but I cannot change it as it is written, sir.
It's all right. It comes to this. We don't mind. I mean, you can't scare me away from a payday, bro.
You can't.
Go ahead and.
You can't scare us away from a payday. I mean, you cannot scare us away from a payday. If there's a payday in this, and you've got actual, because you guys got qualified immunity.
It was good talking to you.
You have a good day. All right. Let's take a look at this ordinance that was presented to Ryan and his audit in Alachua County. This is 337.406. And let me take that back. This is a Florida state statute, not an ordinance. This is actually a state statute. And if you look top, you see that this was the 2024 Florida state statutes, and is including the 2025 special sessions. So this is the newest variation of the Florida state statutes. In the special Session C up there, Special Session C, that was all about immigration reform that they passed between February 11th and February 14th of 2025 is included in all these new statutes, or all this updated revised statute for now. In this statute, 337.406, unlawful use of state transportation facility right-of-way penalties. So this is going to be important because the deputy that stopped Ryan, Deputy Myers, had a partner with him named Deputy Aldus. And Aldus quoted this several times with that back and forth argument that Ryan was making with them concerning what's the constitutional right. And he's just saying, I'm not going to argue with you. We're going to find out what's going on here. And that's why he comes back and we take a look at what's being stated. Now, I then had a conversation with the sergeant who says he won't take discretion away from his deputies. And his deputy is obviously interpreting this to restrict panhandling, which, as we all know, panhandling or soliciting for alms on a public right-of-way is a constitutionally protected right that has been found that way by both the judicial and the legislative branches in basically every single case. But the executive branch does not seem to get it. So on this one, it says, and I think they gave you plenty of time to read this, so I'm not going to read it verbatim out loud, but one part that comes to, we talk about Justice Clarence Thomas in the Reed versus Town of Gilbert case, which was a sign-oriented case about sign content and the size of signs for a church and about sign laws. But the one thing that was found in the Justice Thomas's decision was that no content-based freedom of speech restrictions could exist. So in that case, it was about because it was a religious content. But what was established was no content-based restrictions can exist because they would not meet the strict scrutiny needed to restrict the First Amendment. So in here, as we see, I talked to the sergeant who says it prohibits everything, any act. So he's saying it's blanket. There's no content-based restrictions on here. And it says, now we'll start with why, the spirit of this law. This law was written and presented as a traffic flow issue, safety and health of pedestrians, safety and health of motorists, distracted driving, that type of issue. That's what was presented when they created this, and that was what it was pitched for. But down here, it says, failure to prohibit the use of right-of-way in this manner will endanger the health, safety, and general welfare of the public, and that's what we just discussed there, by causing distractions to motorists, unsafe pedestrian movement within travel lanes, sudden stoppage or slowdown of traffic, rapid lane changing and other dangerous traffic movement, increased vehicular accidents, and motorist injuries and fatalities. That's the reason they need this statute, is what they're saying. Such prohibited uses include, but are not limited to, let's see here, the free distribution or sale or display or solicitation for free distribution or sale of any merchandise, goods, property, or services. That sounds like content-based. The solicitation for charitable purposes, that's content-based, and that's the panhandling part. Solicitation for charitable purposes, which we have found that is very constitutionally protected. Soliciting for alms is constitutionally protected, but they just made it illegal. They said it's illegal to solicit for charitable purposes anywhere on a public or state, call it a state transportation facility. So back to what we were reading. Okay. The servicing or repairing of any vehicle except in rendering emergency service, the storage of vehicles being serviced or repaired, and the display of advertising of any sort. And that's very important because that means that no politician can use their campaign signs. You can't campaign about issues. You can't talk about the issues that are being politically campaigned on. It means it's restricting churches, it's restricting everyone from the display of advertising of any sort, except that any portion of a state transportation facility may be used for an art festival, parade, fair, or other special event if permitted by the appropriate local government entity. And then it goes on to the permitting process to be able to basically shut down a state roadway, or it says facility, but the Deputy Myers or Deputy Aldus in the Alachua County Sheriff's Department thinks that the roadway itself is a facility. But it's saying they may issue permits of limited duration for the temporary use of the right-of-way of a state transportation facility for any of these prohibited uses if it is determined that the use will not interfere with a safe and efficient movement of traffic and the use will cause no danger to the public. So basically now they're regulating the right-of-way on the roadway. And I will agree that the definitions of state transportation facility does seem to include roadway. I will agree with that. But they're limiting and saying they can issue permits to allow certain people to do it and certain people can't do it. But it being anything, basically any advertisement, display of anything. So that means that it should be enforced on politicians and civil rights groups and political rights groups and anyone that tries to put a yard sign, businesses, your mowing companies, and anything that puts something on the right-of-way by the sidewalk would be subject to this. And not someone holding a sign. A sign itself is enough to violate this ordinance. And so then, after it talks about permits, it says persons holding valid peddler's licenses issued by appropriate governmental entities may make sales from vehicles standing on the right-of-way to occupants of abutting property only. That is giving someone special privileges. You know, that makes them a first-class citizen. They get as long as you have the peddler's license, you can first class. Now you're allowed to violate this law because it's illegal for anybody else, but not for you. That has also been found to be unconstitutional, and it violates equal protections under the law, which means that's challengeable under that one too. That's number 2. Number 3 says the Department of Highway Safety and Motor Vehicles and other law enforcement agencies are authorized and directed to enforce this statute. Number 4, camping is prohibited on any part of the right-of-way of the state of a highway system that is within 100 feet of a bridge, causeway, overpass, or ramp. Then number 5, the violation of any provision of this section or any rule promulgated by the department pursuant to this section constitutes a misdemeanor of the second degree, punishable as provided in S 775-082 and 775-083, and each day a violation continues to exist constitutes a separate offense. So this is a law that is completely unconstitutional. And the Alachua County Sheriff's Office is using this law against panhandlers on Newberry Road and Tower Road, which are 2 county-maintained roads to begin with, not state-maintained, that I know of. I'll double-check to make sure Newberry is county-maintained, but I'm pretty sure I'll go look at the signs, the back of the signs, and see who issued the signs down there to verify. But I believe those 2 roads are county-maintained. So they wouldn't be state transportation facilities, but this law is written in a very vague way that even a semi-intelligent deputy or officer, which is hard to come by to begin with, could misinterpret this to prohibit, be legislatively sound, to prohibit someone from holding a sign that is a statement, an advertisement, not a solicitation, but a statement on the right-of-way next to a roadway on a sidewalk or otherwise, which has long been considered to be constitutionally protected activity. So that is what we are looking at here in Alachua County, and I'll show you the video now, or I might have already played the video. But yeah, I'll show the video now. I think you should know about all this before you see the video. Now I will show you the video of the auditing data we're collecting so far on this particular audit.